if we can put our money where our mouth is, so to speak, and say, look, we really don't care about the billables as much as you think we do. I can go out to opposing counsel who love to say things like, we'll be fighting this till kingdom come because they're just going to be charging the insurance companies. I can look at him and say, it doesn't matter to me. That's not how we work. And I like to take the wind out of their sails that way.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hey everybody, welcome back to The Defense Never Rests. I am your host, Trisha Baxter, and today's episode is all about alternative fee arrangements. Most law firms on the defense side are still very much on the hourly billable model, and there's a lot of criticism about that. So we're going to get into that. Before I do, I just want to say, if you like what we're doing, please hit that subscribe button, give us a like, a rating, a review, what have you. I appreciate that. Joining me as a co-host today, backed by popular demand, is my partner, Megan Henry. Hey, Megan, how are you?
Hi, I'm great. Glad to be on today.
Yeah, I think this should be an interesting discussion. I think a law firms are re-looking at many of their processes. In the wake of COVID, a lot of their processes have had to change. And I think having this discussion now and renewing this idea that maybe alternative fee arrangements are a good thing it's good timing.
Yeah, I think so. And I think it's something that people are going to start revisiting and talking about more, especially as COVID continues and everyone's just looking at how to reevaluate their old models. So I think it's really timely.
So on that note, we're going to welcome our guest. So today's guests are very squarely in the space of alternative fee arrangements in some way, shape, or form. They've lived this, walk the walk, and I love that they're on because Megan and I know nothing about it. I've never had an alternative fee arrangement. I'm squarely in the hourly billable space. So having these three guests to really educate us and have us have different viewpoints, I think is going to be awesome. First up, she is the Litigation Management Counsel for the Western region of Liberty Mutual, Diana Dearman. Hi, Diana. How are you?
Hello. Thank you for having me.
I'm so happy when I have industry people on because it's really who I want to talk to the most. No offense to everybody else on this call, but you have such great information. I definitely want to pick your brain. Also joining us, she works with Diana and also does a lot of the alternative fee arrangement, is a partner at Mick Sanders Thompson in Seattle, Washington, Jackie Jensen Erler. Hey, Jackie, how are you?
Hi, good. Thank you for having me today.
Thanks for coming on. I'm so excited. And last but certainly not least, some people would say he doesn't need an introduction, but he is the managing partner at Schenker Law Firm, Steve Schenker. Hey, Steve, how are you?
Hi, Trisha. How are you? Thanks for having me.
Good. Steve and I met through LinkedIn about 6-7 months ago, and what struck me about him was that he is super honest about the fact that he thinks the hourly billing structure sucks. I mean, can I say that? That you are very much in this space, so I love it. So let's start with I'll pose the question and we'll go around. I'll start with you, Diana, if you will. Why is the hourly billable structure so bad?
Wow. How much time do we have?
As long as you want to talk about it.
I mean, first I should say as my disclaimer that the viewpoints that are given here today are my own personal viewpoints and my own professional experience, but don't represent the views of Liberty Mutual Insurance. So just to be clear about that. So to answer your question, the billable hour model I think we've all seen, has shown some inefficiencies for a long time. If you have had your bills gone through any insurance company's auditing process, you'll have experienced what the insurance companies view as inefficient billing behavior. So one way to alternatively look at paying for lawyer services and paying a reasonable fee for those services given is to consider an alternative fee arrangement program. So that's basically paying a law firm a flat fee for an agreed upon scope of work, and that could take many types of forms.
What about you, Jackie? What's your take on why maybe that's not the best way to approach a financial situation?
Well, I do have to back up, and during sort of your intro to me, you mentioned that my firm, while you're right, we do work a lot with Diana and Liberty Mutual. We actually have not adopted an AFA agreement yet. So we, though, have eliminated the billable hour requirement for our attorneys. And I shouldn't say we eliminated it. We never had it to begin with. So
That's
but
fascinating. We're gonna have to deep
Yeah.
dive into that.
Yeah, we will. We will. But to answer your broader question, the inefficiencies, I echo everything Diana just said, but I would also add that it really, internally, from the viewpoint of as a partner at a law firm that's mid-sized for Seattle standards, there's just so much competition that doesn't need to happen when you have billable hour requirements. We like to think that our attorneys should be focusing on driving their cases forward and not their billable requirements forward. So you can kind of spiral that out in so many different directions, but for purposes of talking about AFAs and the industry at large, I think just eliminating that within the firm, you're going to see so much more efficiency in work quality and your output and your relationship with your clients and partners. And I could talk all day about it as well, and I have spoken for hours on this issue at various conferences as well. But I would just say, sort of to kind of cap it at that, the efficiency factor is really the biggest for us.
What about you, Steve? What are your thoughts on this?
Well,
That little evil smile that comes out.
well I never want to say anything bad to those who prefer billable hours, whether you're the client or the lawyer. It's a matter of preference. But in my experience, I offer clients either, but I put the caveat that I wholly suggest that you go forward with an alternate fee arrangement, a flat fee arrangement, or something that's different than hourly, because you're not going to like it as much as the other.
So, all right, let me see if I can pull out some themes in. Inefficiency is one of them, and we can dive into that a little bit more. Is it there a sense that the attorneys on the billable hourly front are overly billing, that they're fluffing? Like, is there a trust issue? Do you think the flat fee arrangement kind of promotes that trust more than the hourly? What do you think, Diana, on that one?
Yeah, I think depending, it all depends on every firm. Firms are different in terms of their efficiency in billing and how they approach billing and how much they might internally maybe perhaps mark down for tasks that they've completed or done. But generally speaking, what we see, if you have a line of business where you have a sufficient volume, where you can see what cases are costing over a period of time from both a time perspective and expense perspective, then you can analyze what makes sense from a flat fee perspective for that line of work. Just say like personal auto, for example, is a line that would be appropriate potentially for an AFA. And in developing an AFA relationship, for that to work, you really need probably several different things to be in place. First of all, the firm itself needs to be aligned and receptive to the program, the AFA program, the entire firm, the executive team, the associates. There needs to be complete buy-in to the concept of the AFA program. And generally, for firms and carriers to analyze whether or not the program is profitable or productive for both sides, and that's the only way it's going to work, is if it works for both sides, is it takes time and it takes volume to see how that plays out, and maybe if any adjustments need to be made to the program, the pricing, if it's a tiered or phased program, that sort of thing. So the other thing is the firm really needs to know its own internal metrics and what it costs to defend these types of cases, and also how it proposes to staff them, which could be with more senior timekeepers, it could be with more junior timekeepers, but it needs to be with timekeepers who have bought into the concept of the AFA and have bought into that efficiency model that underlies it, because really the only way for a firm to make the AFA program work is to have those timekeepers who are motivated to be proactive to move those cases forward to completion. Because as Steve was talking about, the fireman model, the reactive model of just waiting around and we'll get around to taking the plaintiff step and whenever we want to take it, and we're going to wait here and see if we can get some discovery in the meantime, and in the meantime 6 months, 9 months, 10 months has gone by and really nothing has happened. If you have an AFA program in place that's paying you potentially for a tier program where maybe you get paid a certain amount through a certain phase of discovery, then that's going to incentivize you to move that case along faster. So you need to find the right lawyers who work within that structure, and that isn't every lawyer, to be sure. So you have to have the right team in place. And then you have to have monitoring, and you need to have someone who is truly dedicated to monitoring that AFA program, to monitoring who's being effective from the firm side and how the metrics are playing out and the results are playing out for the firm. Because as Steve was saying, adjustments can be made. We enter into at Liberty Mutual, we enter into programs, but over time, if firms come to us with detail about how a program needs to be potentially adjusted, then we can take that back and analyze that and work with the firm and potentially make those adjustments, because it is a two-way street. So you need to have that two-way street, you need to have that transparency, and you need to have regular communication in terms of how the program's working.
So let's dive into the specifics of it, because as somebody who is squarely in the hourly billable front, I've got a couple partners that do some flat fee arrangements, but I don't understand them. How do they work from a logistic operational? Is it every case gets you bill, you get like a retainer, or is it a monthly charge? Can one of you take a stab at just describing one model?
Sure. Why don't I start, and then Steve, you probably had more experience with some other more creative models as well. There's different potential approaches, but one way would be to you would start with a particular book of business, like I said, for example, using the personal lines auto book of business, and so any case that might be an auto case for whatever the venue is would fall into that program, which could be a flat fee per case. So you could say roughly, just for sake of purposes, $10,000 to defend that case. Sometimes you could see that in phases, so that you might have like a settlement answer only phase, you might have a discovery phase, you might have a trial phase, and you might get paid a certain amount, per phase, per completion of those phases. So that's how one model can work. And then you could have built into that program, for example, a couple of opt-outs for the firm. So if they get into a particular situation where they have a case where they are, you're not going to be able to defend this wrongful death action for $10,000, then the firm has the ability to opt out of a certain number of cases over a certain period of time to help manage the risk of cases that don't fall within, where we would analyze the case falling out as being on average $10,000 per auto case.
So let me throw an example at you, because we do a lot of premises liability, and the metrics on those from what we spend on the average, slip and fall case is they're pretty much in line. That would be something that would be ideal for a flat fee arrangement, right? But
yes.
What about the flip side? Like, we do a lot of product liability and aviation cases where the defense costs are drastically different. Would you opt out certain areas of the law, or how does that operate when you have more complex cases?
In the end, I try to say, let's keep everything to the extent we can all agree to be under all one arrangement. So that way there's no disincentive to not work hard on the more difficult cases, because at the end of the day, if you do bad on the more difficult cases and you don't prove your value on those, then what are you worth for the easy cases? So
yeah, I would
include everything.
Oh, sorry to interrupt.
Right.
No, I would just follow up with that to your question, Trish, saying that in more of the premises liability or commercial insurance GL arena, which is also appropriate in our opinion for AFA programs, you're going to see commercial cases that are quite complex, because as you know, plaintiffs' attorneys are always trying to plead some cause of action to get a hook on coverage. And so you can have basically a business dispute that's coming in under the AFA program. And again, it's looking at the long term. So we basically need several years of data to be able to analyze how effective the program is working for both sides. But to Steve's point, it really is, you have to look at it over time. So if you look at it on an individual case as it comes in and you're like, oh my gosh, I'm going to take a bath on this $10,000 wrongful death case, that's not the proper mindset to look into it, because you're going to be looking at the volumes of referrals that you're going to get over time. And to his point, if he's able to resolve that on the early end, then that's a windfall. And hopefully as you analyze that data over time, it's going to be a win-win for both sides. If it's not, then that's when you need to come back. You need to be in communication and adjust what's happening potentially.
But what about those cases that take that giant left-hand curve, like suddenly you have a traumatic brain injury that, at the initial onset didn't seem like it wasn't out there. Now suddenly counsel comes to you, it's like, oh no, this is TBI, you're going to need all these other experts that, weren't foreseeable at the outset. I mean, is there opportunities to come back and say, look, I know we talked about the fee arrangement to be X, but now we're looking at Y.
I think it depends on the program and what's happening with the case. I think it always comes down to, the communication about the program, how it's working, if the firm potentially has the ability to take an opt-out on that particular case. If not, it really goes into looking at what's happening as a whole. I mean, it's not going to work if it doesn't work for both sides. But that being said, it doesn't work for the carrier if the firm is constantly coming back to the carrier on every file and asking for it to not be in the program.
And that's where my head goes, because I think about, and I think I'm nitpicking a little bit to say, like, the complex product liability cases. I have attorneys that have 5 cases on their caseload because they're so complex. And if they were at 10,000 a pop and they're handling that for 3 years, they're making, how do I do, what's 10?
But we wouldn't
grand.
price out a complex products liability book of business at 10,000. I mean, that was given for just an example, but yeah.
That's where my head goes. I'm like, even if it was 50 grand, right? Even if it was, well, maybe 100 grand would make more sense, but some of our products are more, but I know that I'm nitpicking. So that would be something that we would probably clearly be in the opt-out, like the stuff that's going to go on for years and have super complex that somebody has to spend a ton of time on. And I don't want to focus all of this on that. So what about the mechanics of it? So we get this standard slip and fall case that is the run of the mill, same old that we normally get. Let's go with the $10,000 figure. Does the insurance company just pay the $10,000 up front? And then per stage, how does that work?
Yeah, so there's different programs. So it depends on what your program is and how it's been set up and negotiated. Some programs are set up to be just one flat fee for that case. Some programs are staged where you get paid a set amount for, let's say, the answer only settlement phase, and if that's all you complete, then you get paid X amount for that, and then there's another agreed upon set fee for discovery, and then there would be another set fee for trial with a maximum agreed upon flat fee for the total of the case. So that kind of controls what Steve was saying. Let's say your case comes in, you think you're going to do all this discovery, it might be a wrongful death case, and then all of a sudden the carrier's like, oh wait, this is excess, we need to settle this right now. And the lawyer doesn't really do anything but get the settlement documents in place and make sure that, all of that's been taken care of. Is that a reasonable rate for Steve to get $10,000? I would argue no. That's why it makes sense to potentially have a tiered case where we're paying Steve maybe, $2,000 to do that work, not $10,000. So it depends on the program. And then in terms of additional logistics, it's, I don't know how other carriers operate, or Steve, how you've seen it done, but we require our firms to also shadow bill their AFA files, just like it were a regular hourly file, and then submit that billing to us consistent with the guidelines. So while those bills aren't audited for guideline compliance, those invoices provide data to both sides down the road in terms of seeing how effective the program is operating, in addition to providing any kind of assistance the firm might need should your client question, whether or not the firm was really putting all of its effort into an AFA case. If you can show in your shadow billing that you did all the same tasks that you would do on an hourly file, that should satisfy that concern. And then sometimes, obviously, there's an opportunity to recover attorney's fees in commercial cases, so you want to still keep your contemporaneous time. So that will help, both sides, looking at that shadow billing over time, evaluate the effectiveness of the program as well.
Well, let me challenge you on the flat fee per month, because you're still getting paid if you're not doing any work, right? And does that like not incentivize you to drag them out? Not you personally, you know what I mean? Like, doesn't that create an incentive for lawyers to drag it out? Doesn't that have the same critiques as the hourly billable system?
If you're the type of person who is going to do that, yes, it does have the potentiality for abuse, but I think it would be obvious to your client whether or not you're doing that. And it may not become obvious on month 1 or month 2, but over the course of time, and I don't mean over the course of years, it's going to be obvious that cases are taking a long time. Why is that?
Well, I would pose like the same question to Jackie. Like, if you don't have the billable, if you're not looking at the billable hours and you're not tracking attorneys' billables, how do you, as like a manager and a partner, make sure that everyone's doing what they're doing? Because I mean, at our firm, the proof is in the pudding. Like, you just look at the hours and everyone's working. Yeah. So how do you keep tabs on, other than just trusting that your employees are doing what they're doing? I mean, how do you keep a watch for it?
No, it's a good question. It's the question that we get all the time when people hear we do this. What are you thinking? Like, how do you get paid? How do you keep your employees honest? Like, what? You're crazy, right? No, so it kind of, it's holistic. Well, you have to look at it, but it kind of starts from square one, which is when you bring an attorney into the firm, are they a good fit for this model? Are they self-starters? Is it proven by their references, by their work product, writing samples, etc., word on the street? We routinely take people who want to be in courtrooms, who want to be out litigating, who are self-starters. So not a lot of sort of desk jockeys at our firm, which is good and bad, right? Somebody's got to write the briefs, but there is no conceivable way you could ever say we don't look at hours. Of course we look at hours. I mean, that's how we get paid as a firm. So just like any other firm, we're looking at how many hours were billed that month. But what's important to us is not, did employee or attorney A bill over X amount of hours this month? It's, did they bring in the money that they billed? So how much of that time was cut by the auditor? Did they close the cases? How many new cases did we get in as a result? So we're tracking things on our metric level that are different than just time billed. And I will say that the reason this model works and has worked for about 10 years now is that we see the efficiency is sexy, to put it bluntly. When carriers like Liberty Mutual and other partners that we have see that we're taking a case and we're trying to close it for them, we're trying to resolve it, and we pick it up and we say, oh, this has got trial written all over it, there's no way out of it, we're gonna have to try this. Or, hey, I can make a phone call tomorrow and we can probably cut out a lot of really unnecessary discovery and get this done. That carrier, that adjuster gives us 2 more cases because they like that model. They're tired, just like everybody else is, of the old model. I'm finding, and I think anyone in my firm would repeat this, that, they don't like sending the monthly email. Hey, what's going on in this case? Hey, can you tell me where we are in discovery? Your litigation, initial plan said that we'd have answers by now and we'd have a deposition done by now. Can you, I haven't seen a report come in on that. No one wants to see that. And we actually, I think, we really try hard to avoid that. So the tenor of a lot of our teaching and the way we train a lot of our younger attorneys is be ahead of the ball. Always, you be the one moving it forward. Even if the other side is giving you plenty of reason to sit on your laurels and they're precluding you from doing something, go out, like Steve is saying, and be offensive. Be the best offense, or the best defense is the good offense. So we do that. And I think it's earned a pretty good reputation for our firm as far as being proactive and getting results versus driving up the billable hours. I don't think that it's a big secret in the industry, and I think Diana could speak to this too, that there are a number of firms that simply want to keep files open so they can bill them, when in fact those cases could be closed so quickly, and you can make room for the bigger, meatier commercial cases that require a lot of attention. It'd be my dream to have 5 cases that I could just sink my teeth into and work up for trial, because we can win it at trial. And you know, so to that end, what I do is, you know, I look at some of the maybe more routine cases, like auto cases that are coming in. And if I have a relationship with that attorney, then I know we can probably skip a lot of steps and get to the bottom line that makes my adjuster happy, that serves my client, and that gets the case done. So that's a really long-winded way of answering your question, Megan, but we look at other metrics that are more kind of gauging the efficiency of that attorney, because the quality and the product we give our clients and our partners really does, it is a good return on investment. It really does bring more work in for us.
So let me make sure I understand. So you don't, your associates and partners don't have a billable requirement, right?
Correct.
But they are still billing.
Yes.
And the metrics that you use for raises and bonuses have to do with file closing, how many new files came from that. That's fascinating. We don't track that probably nearly as good as you are.
Yeah.
So I may call you separately off this podcast.
I mean, yeah,
you just gave her an idea.
I'd be lying if I said we don't look at hours, and I'm very clear about that, because of course we do. But our bonus system is, you know, without giving you all of our secrets, our bonus system is very discretionary, and we do look, of course, at hours. But I will tell you that there's never been a time when we've looked and said, oh, this person's just not billing enough, because we know why maybe their bills are lower than this person's. And we know it's because there was work that went into marketing, or a bigger project that will ultimately serve the firm better, or a case that we cut some time because we know that the work that was being done was really good, but wasn't something that, you know, the level that our clients and our partners are expecting would have taken that long. So things like that, where we're giving people grace on that, and it makes happier attorneys, and it makes for better work quality, and it doesn't make us look like we're just running up those charges. So anyway,
let me throw you a hypo then.
Mm-hmm.
You have, and let's just say, because I don't want you to talk about anything that's happened on your firm personally, but let's just say you have 2 associates, one's hitting 2,000 a year and one's hitting 1,000 a year. Is that alarming, or do you look to say, all right, 1,000 a year?
That would be alarming. I mean, 1,000 a year, it'd be like, are you working? So we would not, here's the thing. We don't ever, my firm is never in a position where we have too many attorneys. I'll say that. We're all working a lot. And I'll speak personally, I'm busier now with this firm than I've ever been at other firms. And I have just as many cases. I think I'm just incentivized differently to get the cases worked and done, and get new ones in. I find that a little bit more exciting than, oh crap, we're going to get the race sheets in like a week, and I'm going to be doing worse than my colleague next door, and someone over in Philly is going to hate me for this, or whatever, you know. It's just way less stress. So if I see though that associate A is billing 1,000, I'm going to be like, they need more work, or we need to have a talk about what they're doing during the day. But frankly, it just isn't an issue we've had. So knock on wood.
I might have found your Go ahead, Diana.
Oh, I would just really echo what Jackie had to say about the metrics, and really getting a program in place to understand your firm's metrics in terms of, you know, how, what we call closed case outcomes. So how much it's costing in terms of fees and expenses per case, per line of business. So let's say you do employment defense. So, you know, over time, you know, you should be tracking how much those cases are costing. So you can both average that out and do a median analysis on that, as well as cycle time. And so in addition to the metrics that Jackie was talking about for your individual timekeepers, but really having a robust understanding of your data in terms of how much you're making on these cases and how productive your timekeepers are will help inform your firm if your firm chooses to enter into an AFA program, because the only way that it'll be a successful program is if you do understand your metrics and you have that data refreshed on a regular basis, and again have anybody who's on the leadership team, you know, understanding that data. And then the second point, I just wanted to follow up on Jackie's comments about their firm not using billable hours as the measure of success for attorneys. The firms that we've had the greatest success with for alternative fee agreement programs recognize that their attorneys who are successful in handling those cases bring a great value to the firm and to that client relationship. And they've figured out other ways to recognize and bonus those attorneys based off of their success in handling those AFA cases. So there's a need to think outside the box in terms of efficiencies, and then definitely metrics and keeping track of your metrics, so that also if you are in an AFA program and you want to approach the carrier with adjustments, you need to be armed on your side with your data, so you can come back to the carrier and say, this is what we're seeing, and here's our data, and this is the adjustment we're requesting because of X, Y, and Z, and you can see it right here, and the carrier can take that under advisement, as it were.
Well, let me throw something at you, and let me just be a proponent of the hour billable system and have you come back at me and tell me I'm completely wrong. I would love to have somebody just throw it in my face, and I'm not afraid to be wrong, even on air. So a lot of what you're saying, I feel like we do, and a lot of firms on the hourly billable model do. I want to close a case as fast as the flat fee person, because I'm all about long-term relationships. And I know that most of my clients are not the clients that are, let's go to trial. Like, I'm ready to spend a lot of money and let's litigate the hell out of this case. They're just not, they want you to shut files down. So our internal processes are very much geared around that, but we still have on the compensation and bonus structure very much tied to billables. So I feel like if you are dealing with a firm that does care about long-term relationships and want to close file, you're going to get that on the hourly billable system anyway. What am I missing, and am I wrong?
Yeah, I'll jump in here. There are two things that spring to mind. One is I kind of have to, because I'm from Seattle, I get a little woo-woo, but I have to bring it back to this, there's a human component to all of it. And when you have attorneys who are focusing their stress that is so inherent in litigation anyway on the files themselves, and not on competing with their peers for billables and for that bonus at the end of the year based on a number, I think they're happier. Our turnover rate is extremely low. We've had one associate leave for another firm in 10 years. We've had, I think, 2 or 3 others leave for positions with one actually left the state, so that's different, and one with a court of appeals. So totally, our model is keep them happy, keep them here, because it does take a lot of money from an economic standpoint, a business standpoint, to onboard someone and bring them into our sort of fold, but also because we just want to be good employers. We want to buck the trend that you have to get in there as a young associate and grind. We want people to be happy. So by throwing the billable model sort of to the wind, and you don't have to eliminate it altogether, but maybe not put such a premium on it, I think you're taking a lot of the stress away from your own employees and helping them focus on getting the mentorship they need to solve the problems in their cases, not be afraid to ask the questions that they're going to say are dumb, but they need answered, and to collaborate more instead of being so scared of not billing as much as their counterparts next door. So the second part of that is, you touched on it, the trust, the relationship with your partners, and just sort of, that's also so paramount to us, I'm sure to your business as well, everyone on this call. If we can put our money where our mouth is, so to speak, and say, look, we really don't care about the billables as much as you think we do, because we're not racing against each other for the billables. I can go out to opposing counsel who love to say things like, well, Your Honor, we know that they're getting paid to do this and they'll come run us back in, and we'll be fighting this till kingdom come because they're just going to be charging the insurance companies. I can look at him and say, it doesn't matter to me. I don't get judged or bonused on these billable hours that I'm bringing in. Look at my website, look at, talk to my clients. That's not how we work. And I like to take the wind out of their sails that way. So that's just one little thing. But then also to show, people like Liberty Mutual or clients like Liberty Mutual and others that truly we're not incentivized by that billable model. So you can trust us to really try to push our cases sort of to resolution rather than high numbers. I think that when they see that that's literally what we're practicing and implementing, then they trust us a little bit more. So those are my two sort of, the humanity behind it, the human aspect, and the partnership, and yeah, trust, I think is the best way to put it.
I'm with you hands down on the mental health stuff too. Like, associates
Especially
are definitely,
now, right?
especially now, you take
Yeah.
away the billable, you legitimately take away the billable requirement. And I can see that, that you have me hands down.
Yeah.
Beat. I think that
I feel like I wouldn't have such an anxiety disorder if I like hadn't had billables early in my career.
What about you, Diana or Steve? What do you think about my take on why I think the billable model is a good one?
I'm not against it. I do it actively. I'd say maybe a third of our practice is billable hours, but it's the client's choice. At the end of the day, I like to provide them with as many options as possible. And they say, well, which do you prefer? And I say, me, I don't. It doesn't matter to me. I think this is going to work better for you, but you be the judge. And at the end of the case, it'll come out where either they're going to say, oh, I wish I did the other model, or in the future, I'll do that model. But I guess the biggest problem is it's human nature. I mean, there's times where I've had to go out and speak to our corporate lawyer about whatever it happens to be. And I get the bill and it's like, come on, you mean to tell me that you spent 3 hours doing this? You mean to tell me you spent 4 hours doing this? And I'm a lawyer that does billable hours. And it's human nature. I want to, I don't, but I want to call them up and say, come on, did you really do this? But then that would be going completely against everything that I do, where I don't want people calling me up and saying, well, did you really work 3 hours on this motion? Because of obvious reasons, but it just seems to be inherent in the nature of it. And
I have a client who tried flat fee, and I don't remember what model he used, but all I remember is he stopped it because he didn't like it. He found that it really just promoted a little bit of laziness. Like his attorneys didn't do the deep dive on some of the cases that needed the deep dive. What do you say to that? Do you find that to be a problem in the AFA modeling situation?
I would say again, it comes back to the management of the program and the firm and who the firm is selecting to work on their AFA files. But at the end of the day, we all have a duty to be competent and to diligently represent our clients. And if we've agreed to whatever fee agreement we've agreed to, then we need to ethically perform our duties within that arrangement and continue to do whatever tasks need to be done to defend that case. So I would say that, really, the flip side of that, and I think that's what Steve was trying to say, is that, obviously you want to have attorneys who are proactive and efficient and who are going to move the cases on and aren't going to let these cases wallow. But at the same time, it does allow the firm to undertake whatever tasks, I think Jackie was making this point too, that it needs to take without worrying about overbilling on a task and then cutting the time and then dealing with all that back end issues that happen if you go through the invoice adjustment process and all of that. So that's what I guess I would say about that. I mean, I think the way that we can, on our end, we have metrics that we can see how the cases are progressing through the shadow billing to see if a firm is being efficient or inefficient. And so that informs us as well. And then of course we get claims feedback, and if claims is telling us that, the firm it's their perception that the firm isn't advancing the case because it's an AFA and it seems to be some kind of trend, then, we can look into that. But that generally hasn't been our experience. I think it really comes down to the firm to select the right timekeepers to work on these cases.
Yeah, I mean, I think that's a great point, because I mean, obviously I'm not in it, so I don't see how people are handling the AFA situation. I have this perception, though, that when I put up two cases, one under the AFA model and one under the billable model is going to say, all right, what depths do I need? In a standard slip and fall case, you're going to take the plaintiff, they're going to probably get a corporate designee, but what about a witness? And in the hourly billable model, we're going to say, do we really need that witness? Probably. We probably need to take the deposition of that witness. Maybe in the AFA, they say, I'm not going to do that effort because it's just more time and money. But I guess I'm hearing from you, or not money, but more time. I guess I'm hearing from you that that's just not your experience, that you find your lawyers do what is necessary to advance the case. Is that fair?
I think that's fair. I mean, really, another thing that underlying this is the best practices aspect and partnering with claims in terms, regardless of whether it's an AFA or an hourly case, our expectation is that you're going to partner with claims from the outset on what the agreed defense plan is and agree what tasks need to be done to get that case to whatever the agreed upon resolution for that case is, whether it's mediation, we just need to get some medical records in the plaintiff step, and then let's get this into mediation. So I think being aligned on what that strategy is and advancing the case and advancing what those tasks are efficiently really shouldn't change. In my opinion, an hourly case shouldn't be handled any differently than an AFA case. They should both be handled the same in terms of the strategy and being effective in terms of what information and what tasks do you need to do to get to the point where you and claims have agreed you need to get to that resolution.
Yeah, and that just wasn't my client's experience. Like when I talked to him, he was like, I did find that people weren't handling cases the same. It was a lot less effort. And then he saw his indemnity payments go up. Do you guys do you compare your indemnity, or have you previously,
Yes,
between your AFAs and your billable? Do you find a difference?
I mean, you could potentially find a difference, but yeah, those are metrics that are tracked so that we can determine if the program is effective or not. But we're going to probably hear back from claims before we see that in the data.
Okay.
They're going to be telling us that the firms are not performing to the level that they think they should be performing, and then we may or may not see that borne out in the data. Or we see it in the data and then we go back to claims, we go back to the firm and we confirm whether or not that's the case. So we don't rely on data in a vacuum.
Quick question. This is totally just out of curiosity, Diana. If that's like consistent feedback that you're getting from claims that for whatever reason the AFA cases are just not the quality that they're used to seeing from specific firms, does that give, and maybe you can't tell us, but does that give you guys an opportunity to reevaluate how much you're offering for the AFAs? Like, can you restructure on your end with, a given market, the amount of the AFA?
Potentially, but that gets into evaluating the whole program and the health of the whole program and what's driving that. And it's, generally it's a competitive market, right? So if we've got other firms who are able to do that effectively, and the other firm isn't, then that might inform the direction that we go as well. So I think kind of underlying this whole thing, I know, Tricia, I really appreciate your defense of the billable hour, but I guess from
I'm just trying to understand it.
The carrier side, I think what talking about the AFA programs here today is just one example of how carriers are looking to get the value added billing, but also looking at ways to be more efficient overall in the practice of litigation, whether it's going with an alternative fee agreement program, alternative fee program, or maybe with the cases that you were talking about, the complex aviation products liability cases, maybe an AFA isn't appropriate in that context, but maybe what might be appropriate in that context is working with an alternative legal service provider, working with a vendor who could potentially help make your document management more effective and efficient than it would be to have that done in-house, or things of that nature. So just being mindful of how the firm might think outside the box to bring efficiencies to the relationship, I think will go a long way with your carrier clients.
And I struggle with that because I obviously I see the bills, and and it pains me sometimes to send them out because I'm like, oh my God, these are so high. Like, and I see what they're paying and I want to be like, all right, how can we change this? AFAs have not ever been something that I thought could work for the vast majority of our practice. Not to say, but I am reconsidering, which is why I'm having this podcast to help me, maybe just personally help me learn. But I've looked into it. I never thought it would work on that, but I absolutely open to looking at ways that we can reduce fees. They're crazy. And I think we're about to see a lot more cases come in where it's going to get even crazier.
Mhm.
And we do want our clients and insurance carrier our insurance carrier contacts to have that good experience with us and not have to pay those big checks. I don't have an answer for it. But I'm glad that we're having this discussion, because I think we should renew the discussion over AFAs. And it reminds me of like just a personal story. We own some real estate investments and some multi-unit family, and we have a property manager run them, and she gets paid a flat percentage every month, whether she is doing a boatload of work or sitting at home watching TV, right? Because I know that the months that she's crazy working, it balances out with the times that she's not. And that's kind of your point, is you have to not look at it as a monthly thing, but a long-term yearly 5-year relationship that over time will be profitable for the lawyer and beneficial for the client.
Exactly.
A lot of people don't care client, yeah.
So I'm kind of a doctor because I do pay a property manager. Well, maybe she's my doctor, but well, I know we're running short on time. I just wanted to ask one final question of the group, and you know, this will be for Diana, Jackie, and Steve more so. What would you say to somebody like me, maybe not me, but somebody who's in that billable model? That how would they get started? Why should they consider it, and how would they get started? However you want to take that question. There's some closing thoughts here.
I'll go first and just say that just to kind of echo what I said earlier, you know, just from a standpoint of maybe, and you know, let's not blame the millennials for everything, but they are going to.
Oh, come on, it's fun too. Let's do
it. There is this sort of level of expectation, I think, for young professionals right now and how they want their work-life balance to feel and appear. That doesn't mean that there's no hardworking associates by any means, but you know, maybe shifting our models to sort of accommodate the talent that's coming out, in the sense that offering flexibility, working from home, not putting such a premium on billable hour requirements, and treating this more as like, you know, we know you're going to put in really good years of your life with us and we want you to be happy and feel rewarded. Here's what we're going to do for you. And along those lines, the legal industry and the defense industry is evolving, especially if you're doing a lot of insurance defense work, because insurance carriers are looking for ways to streamline and be profitable as well. So, you know, there's this sort of trickle down effect you can't deny. So we have to evolve and adapt as they do. And if that means changing our models to fit, you know, our clients' models and our partners' models, then we're going to stay ahead of the game and continue with longevity and to maintain our profitability. So I would encourage everyone to look at it that way, sort of the long game, and tracking how everything's evolving.
If you wanted to go into the realm of alternate fee arrangements, I would say give it a shot, however it be. Do it as a small trial, and if it works, then try with something else. If it doesn't work, then you're not going to take too much of a hit one way or the other, where it wouldn't be worth the effort, because you may be able to keep a client with a different type of arrangement, or you may be able to get additional clients or additional fields with that type of arrangement. I just, in my experience, found that offering client options is what they like. And ultimately, if they pick an option that they don't like, well, I guess it's their fault. Then they'll go back and pick a different option, but it's not us as the lawyer who's choosing, this is how you're going to pay me. I'd rather say, you choose and we'll go from there.
Well, I think to your initial question about, you know, what can you do, or what would you want to do if you're thinking about starting out in engaging in an AFA program, would be to talk to more people, to talk to firms who have successfully engaged in various types of AFA programs, to get their experience and what's worked for them, and both in terms of the setup of the program, in terms of internal processes that they might have put into place, and how they've made that program work. Firms, I think, that are going to be the most successful going forward are those firms that embrace thinking outside the box and thinking about ways that they can be more efficient, whether that's being more efficient with their overhead, whether it's being more efficient with AFA programs, where it's being more efficient by using alternative legal service providers. A combination of all those things are probably what's really necessary, because as you know, it's a competitive market out there, especially depending on where your venue is. And the firms that are going to succeed are the ones who are the most willing to change and embrace new ways of doing business.
Yeah, and I think that what's a great way to end this, because especially our current climate, where like Stephen mentioned before, law firms are so hesitant to adopt anything new and change, but now they're being forced to do it. So maybe this situation, whenever we come out of it, their minds will be open to all these different types of things that have actually been around for a while, but no one's really been open to it. So I think the tide is turning, at least for people willing to consider different things in the operational side of the law practice. So, I feel like we could talk for like another hour. So we may have to do another part 2 to this. If you guys will come back on, I think I appreciate that.
Absolutely.
Yeah. I love that you guys have such real world knowledge, and that we had, I think, an open discussion about these different sides of things. And so thanks for coming on, guys. And if you like what we're doing, hit that subscribe button, give us a rating, a like, a review, whatever medium you're on. I appreciate that. Until next time, we will see you on The Defense Never Rests.